All right, strap in everyone, because today we are diving deep into the crazy world of unlawful detainer in California.
You got that right.
Yeah, so unless you're like a lawyer,
Right.
you're probably thinking, unlawful what now?
Uh-huh.
But seriously though, whether you're renting or you own property in California, this is some legal stuff you got to know about.
Absolutely. It can get very complicated very quickly.
That's right. Unlawful detainer. It's basically the legal term for eviction in California.
That's it.
And we've got like a mountain of sources here.
Yeah.
Legal guides, blog posts, even some actual court documents, all about this, like often misunderstood area of the law.
Exactly. And it's important to remember California is a unique beast when it comes to evictions.
And digging through all of this, honestly, I was kind of shocked by how fast things can go from like zero to eviction.
Oh, for sure.
It's not like those long, drawn-out court cases you see on TV.
No, not at all.
It's like, bam, you're out.
Well, that's because California's unlawful detainer procedure is what they call a summary procedure.
Okay, summary procedure. So in plain English, what's that mean?
It means it's like the express lane through the courts.
Okay.
No messing around. It moves fast.
Gotcha.
Tenants, a lot of times, have very little time to respond.
Really?
Sometimes it's like only 5 days.
5 days?
Yeah.
That's barely enough time to figure out what's happening.
Right, and that's why we're here, to break it all down.
Exactly. So let's get back to basics for a second.
Okay.
What exactly is an unlawful detainer?
So at its core, unlawful detainer, it's this legal process. Landlords in California, they have to use it if they want to evict a tenant.
So there's no more of those like,
The DIY evictions.
you like changing the locks or shutting off the utilities, that kind of stuff.
Nope, not in California.
Interesting. So it's all about making sure things are handled legally by the book.
That's the idea. Fairness for both sides.
I see. So this unlawful detainer thing, it's like really old-timey and official.
Uh-huh, right.
Is this some kind of legal relic from like the Wild West days?
Well, it's actually more relevant now than ever, and yeah, it does have some history to it. The term unlawful detainer comes from this law that was enacted way back in 1872.
1872. Wow.
Back then, evictions, they were often pretty messy affairs.
I can imagine.
Sometimes they could even get violent, you know?
Yeah, so they made this law to like prevent landlord-tenant showdowns at high noon.
Exactly. The goal was to have a clear legal process to settle disputes and to, as one source put it, avoid bloodshed.
Wow, that's pretty intense.
And you know what's interesting is that this historical context, it still shapes how evictions work today.
That's pretty wild. Makes you realize how important it is to have like a system, right?
Oh, absolutely.
So in this system, who are like the main players?
Okay, so in an unlawful detainer case, you've got the landlord, they're called the plaintiff.
Plaintiff, that's the one who starts the whole lawsuit.
Exactly, and then you have the tenant, they're the defendant, the one being sued.
Right. And even though the system is supposed to be fair, it's got to be remembered that both sides have rights, AD responsibilities. Right?
That's a key point, yes.
Okay, so let's dig into that a bit. What are the reasons a landlord can actually file for an eviction in California? I mean, they can't just kick someone out because they don't like your music, right?
No, definitely not. Haha.
So what are the legit reasons?
California law, it's very specific. It outlines certain grounds for eviction. And the landlord, they have to prove one of these grounds actually exists if they want to win the case.
Gotcha. Makes sense.
And one of the most common reasons, and probably the most obvious, is, failure to pay rent.
Right. Seems pretty straightforward.
You don't pay, you got to go, but you can't just kick them out right away.
There's that whole 3-day notice to pay rent or quit thing we keep seeing, right?
That's right. That's a crucial first step in the process.
So walk us through that. What happens?
Okay, so picture this. Your rent is due, and you haven't paid the landlord. They can't just, bust in and evict you on the spot.
All right, got to follow the rules.
They're going to serve you with this notice, and it basically says, hey, you're behind on rent. You got 3 days to pay up or move out.
It's like a legal warning shot, right?
Exactly. It gives the tenant a chance to fix things. But here's something interesting we found in one of the sources. This law firm blog actually advises landlords to get a lawyer involved to help recover back rent.
Really? So even in a simple case of, like, unpaid rent, it can get tricky legally.
It can, yeah.
Okay, interesting. So unpaid rent, that's one big reason for eviction. What other grounds did we find in our research?
Another big one is damage to the property.
So if a tenant, like, trashes the place, the landlord can just evict them.
Well, it has to be more than just normal wear and tear.
Right.
If the tenant causes serious damage to the unit,
Okay.
Then the landlord can issue what's called a 3-day notice to remedy the situation or move out.
So it's like fix the giant hole in the wall or you're out of here.
Pretty much. The tenant has 3 days to fix the problem and avoid eviction. But if they don't,
The legal battle begins.
act.
Gotcha. So those reasons for eviction seem pretty clear-cut.
Yeah.
But I'm guessing things can get a little more complicated sometimes, right?
Oh, yeah, for sure. For example, another ground for eviction is nuisance violations.
Nuisance violations. What's that all about?
Well, it covers disruptive behavior that, affects other tenants or the property itself.
Okay, I see.
Think like constant loud parties, lots of noise complaints from the neighbors.
Right, stuff like that.
Or even things like having unauthorized pets that are causing damage or problems.
So it's not just about damage to the place itself. They're also about how a tenant's behavior affects others.
Precisely. It's about being considerate of everyone in the building.
Makes sense. So noise complaints, unauthorized pets, that falls under nuisance violation.
Right.
Gotcha. And then there's got to be like the most serious reason for eviction, right?
Oh, absolutely. And that is illegal activity on the property.
Okay, so we're talking about
things like drug dealing, running an illegal business out of the unit, anything criminal, basically.
yeah, so that's serious stuff.
No mess around with that.
And in those cases, the landlord can issue what's called an unconditional quit notice.
Unconditional. So that means,
No second chances. The tenant gets just 3 days to vacate.
wow. So they really don't mess around when it comes to illegal activity.
Nope. California law takes that very seriously.
I can see why. And once the landlord has served the right notice and the tenant hasn't done what they're supposed to,
That's when it kicks off.
that's when the formal eviction process, the unlawful detainer lawsuit, begins.
Right. Things start moving fast.
Okay, so we've laid the groundwork, we've got our players, we know the reasons why an eviction might happen. But now, let's talk about what actually happens when that notice period is over and things escalate to a full-blown eviction lawsuit. What are the steps involved in this legal showdown? We'll find out in the next part of our deep dive.
Looking forward to it.
Welcome back to our deep dive into unlawful detainer in California. So last time we were talking about those 3-day notices and all that.
Yeah.
Right, setting the stage.
Exactly. But now let's get into like the nitty gritty.
Okay, yeah.
What happens when that notice period runs out and things like blow up into a full-on eviction lawsuit?
All right, so this is where it gets serious.
Okay.
Once that 3-day notice is up and the tenant hasn't, done what they're supposed to do,
Right.
the landlord, they can officially file an unlawful detainer complaint
Oh, okay.
with the court.
So that's when it goes from like a warning shot to a full-blown legal battle.
Yeah, you could say that.
And that's where that like super speed we were talking about before,
Arrest summary procedure.
it kicks in, right?
Oh, yeah, things really start moving fast at this point.
Wow. So after the complaint is filed, then what?
Well, then the tenant gets served with a copy.
Yeah.
And this is where those super short deadlines we talked about, they come into play.
You're talking about those like 5-day deadlines.
Like that.
That's barely enough time to like find a lawyer, let alone figure out a defense.
It's tough, and that's why it's so important for tenants to understand what their rights are and to act quickly. If they don't respond to that complaint in time, they could get hit with a default judgment.
A default judgment. So what does that mean, like in normal language?
Basically, it means the landlord automatically wins,
Yikes.
and the tenant is ordered to move out, no questions asked.
That sounds pretty harsh.
It is. It's like you didn't even show up to the game, so you automatically lose.
So let's say the tenant does respond on time within that crazy short deadline. What happens next?
Okay, so then we go to the next round, the court hearing.
Okay.
And this usually happens within about 20 days of the tenant's response.
20 days. That's still ridiculously fast.
Yeah, the whole process is designed to move quickly.
It's like a legal sprint, not a marathon.
Uh-huh. Yeah, that's a good way to put it.
So at the hearing, what goes down?
This is where both sides present their case.
Oh, okay.
The judge, they listen to evidence from both the landlord and the tenant. They look over the lease agreement.
Right. And then they make a decision based on the facts and, of course, the law.
So it's like a mini trial with the judge as the referee.
That's a good analogy.
So then, just like in a trial, there are a few possible outcomes.
Right. Right. So the tenant could win,
Okay,
in which case they get to stay put.
that's good.
And sometimes, get this, the landlord might actually have to pay the tenant's court costs or lawyer fees.
Wow, really?
Yeah, if that's written into the rental agreement.
So there are like consequences for landlords who try to evict without a good reason.
Oh, absolutely. It's not a one-sided system at all.
Okay, good to know. But what about the other side?
Well, the other possibility is that the landlord wins.
Right.
And if that happens, the court issues a judgment against the tenant,
Oh, okay.
along with something called a writ of possession.
All right, hold on. We're getting into legal jargon territory again.
Aha, sorry about that.
So break it down. What's a writ of possession, and what does it mean for the tenant?
Okay, so basically a writ of possession, it's a court order.
That gives the landlord the right to have the tenant removed from the property.
Oh, okay, so
It's the official go-ahead for the eviction.
gotcha. So once that writ is issued, that's it. Game over for the tenant.
Not necessarily. The writ usually gives the tenant 5 days to leave voluntarily,
Like,
a last chance to pack their bags and go on their own terms.
and if they don't leave within those 5 days?
Things can get a little, well, messy.
Oh, no.
The sheriff can actually come in and physically remove the tenant from the property.
That's like the worst case scenario.
It is, yeah, definitely not a situation anyone wants to be in.
Okay, so that's intense, but let's back up a bit.
Okay.
Well, let's say the landlord wins the case. Do they automatically get any back rent or money they might be owed?
That's a good question, and it's not always automatic.
Really?
One of our sources, this legal guide for landlords,
Okay.
it specifically said that getting things like back rent or damages or legal fees
Right.
through the unlawful detainer lawsuit, it all depends on what's written in the original lease agreement.
So it all comes down to the fine print.
Pretty much, yeah, that lease agreement is super important.
And we found another interesting thing.
Oh, yeah? What's that?
If the court decides that the tenant was like intentionally being difficult,
Oh, okay.
like purposely damaging the property or causing a lot of trouble,
Right, like acting in bad faith.
yeah, then the landlord can get a $600 penalty on top of everything else.
Wow, they really thought of everything.
So let's talk about the tenant for a second.
Okay.
If they lose the case, what kind of impact does that have on them?
Oh, it can be pretty serious.
Yeah.
An unlawful detainer judgment.
Uh-huh.
It can stay on their credit report for a long time, like 7 years.
7 years. That's a long time.
It is, and it can make it really hard for them to rent a place in the future.
Landlords, they're going to see that eviction on the credit report.
Oh, yeah, it's a big red flag for sure.
So it's really high stakes for the tenant, but we've been talking a lot about the landlord side of things. What about the tenant? Do they have any options to, like, fight back?
They absolutely do. It might feel like an uphill battle,
Yeah?
but they're not powerless. There are legal defenses they can use to fight an eviction.
Okay, now I'm really interested.
And some of these defenses, they might surprise you.
Really?
Oh, yeah. We'll get into all that in the next part of our deep dive.
All right, stay tuned, everyone. We'll be right back with more on Unlawful Detainer in California. Welcome back to the final part of our deep dive into Unlawful Detainer in California. We've covered a lot of ground here, from the reasons behind evictions to that crazy fast court process and those like really serious consequences if you lose a case.
Definitely high stakes.
Yeah, but before we wrap things up, we got to talk about the tenant side of all this.
That's right, because even though the process is designed to be quick,
Right.
it's really important to remember tenants have rights too. They have options to fight back against an eviction.
Okay, good. So spill the beans. What can a tenant actually do if they're facing eviction?
Well, one of the most straightforward defenses is basically proving that the landlord is wrong.
Okay, so like if the eviction is about unpaid rent,
Exactly.
the tenant can show proof that they did pay.
Right, things like bank statements, canceled checks, money order receipts, anything that shows the rent was paid on time.
Makes sense. You paid, you stay.
Right, but what if it's more complicated than that?
Like a lease violation or something.
Yeah, in those cases, it can get trickier.
So what can tenants do then?
One of our sources, this legal guide for tenants,
Okay.
it talked about this thing called relief from forfeiture.
Relief from forfeiture. That sounds intense.
It's kind of a last-ditch effort, but it basically lets tenants stay in the property under some very specific circumstances.
This is like a second chance.
You could say that.
So what kind of situations would allow a tenant to use this relief from forfeiture defense?
It usually applies when the tenant admits they messed up, like maybe they broke a lease term or were late with rent,
Okay.
but they're asking the court to give them a break.
Oh, so it's like saying, I messed up, but I've learned my lesson. Can I please stay?
Exactly, but there's a catch.
Uh-oh, what's the catch?
The tenant usually has to show that being evicted would cause them severe hardship.
Severe hardship. So Like, it would put them in a really bad spot.
Right, like homelessness or serious health problems, things like that.
So it's not just about apologizing for messing up.
No, they have to prove that being evicted would be really, really bad for them.
And that's not easy to prove, I imagine.
It's not. They need solid evidence to convince the court.
Makes sense. So let's say a tenant tries to fight the eviction and they still lose. Is that it? Game over?
Well, they can appeal the judgment,
Appeal. So that means,
asking a higher court to look over the case.
okay, so they get another shot.
Kind of, but there's a big problem.
What's that?
In most cases, the tenant still has to move out while they're waiting for the appeal.
Wait, so even if they're appealing, they might still have to leave.
Yeah, it's not ideal.
It seems kind of backwards.
It does, and unless the tenant can prove extreme hardship,
Extreme hardship. So even worse than just severe hardship.
right, they'll probably have to move out during the appeal.
So appealing doesn't guarantee you get to stay put while you wait.
Nope. And even if they win the appeal, there's no guarantee they can move back into the same place.
This whole process is sounding more and more complicated.
It is, which is why it's so important to have a good lawyer.
Someone who knows the ins and outs of all this.
Exactly, because one of the biggest takeaways from all our research, whether it was for landlords or tenants, was this: get a lawyer.
It's like having a guide in a super confusing maze.
That's a good way to put it. A good lawyer can help both sides understand their rights, make sure they're doing everything by the book, and really fight for them throughout the whole process.
So lawyer up. Got it. But even with a lawyer, this whole eviction thing sounds incredibly stressful.
Oh, it definitely is.
Is there anything landlords and tenants can do to avoid this whole legal mess in the first place?
That's a great question, and it brings us to another really important point we found in our research.
Okay, I'm listening.
Communication is key.
Oh, okay, so just talking to each other.
Exactly. A lot of these disputes, they turn into big legal battles because of, miscommunication or misunderstandings or just not being willing to compromise.
So sometimes just talking things out can prevent a whole lot of legal headache.
Absolutely. If landlords and tenants can just talk openly and honestly, address problems as they come up, try to find some middle ground,
Right.
they might be able to work things out without going to court.
It's worth a shot.
Uh-huh.
Talking is usually better than fighting.
Uh-huh. I agree. And even if you do end up in court, knowing how the process works, what your rights are, and having a good lawyer on your side, all of that can make a huge difference.
Awesome. Well said. And that brings us to the end of our deep dive into Unlawful Detainer in California.
It's been quite a journey.
It has. We've gone through the reasons for eviction, the steps of the lawsuit, the defenses tenants can use, and how important it is to have a lawyer.
Lots of information to digest.
But, as with anything legal, this deep dive was just a starting point.
Definitely. And it's important to remember that this is just for informational purposes. It's not legal advice.
Right. So if you're facing a possible eviction or thinking about filing one,
Talk to a lawyer.
exactly, a lawyer who specializes in this kind of stuff, they can give you the best advice for your specific situation.
Absolutely don't try to go it alone.
And if you're interested in learning more about Unlawful Detainer, be sure to check out the resources we've linked in the show notes.
Lots of good stuff in there.
They're packed with info and insights to help you navigate this whole complex world of evictions in California.
California is a unique state, for sure.
It is. Well, thanks for joining us on this deep dive.
It's been a pleasure.
We hope you found it informative and maybe even a little bit entertaining.
We try to make it fun.
We do. All right, until next time, stay curious, stay informed, and most importantly, stay out of eviction court.
Great advice.
Call now 714-442-9741. Thank you.